Hey, welcome back to another edition of A Closer Look. This week, I'm with my good friend and business associate for many, many years, John Spina, and we're going to be talking about something that I feel is critical for every family to talk about, and that's estate planning. So, John, I want to welcome you to this episode. Thank you for
Colonel.
joining us.
Thank you.
Really
It's a
appreciate
pleasure.
it. I know a lot of you know John already. We've referred John to many of our clients. And John, why don't we start off just by talking about what an estate is and why people should have an estate plan?
Carlo, basically an estate is everything that one has accumulated during their lifetime.
Okay.
So it can consist of property, it can consist of investments, retirement savings plans, things along those lines. Just an accumulation of wealth for all intents and purposes.
Okay.
So an estate plan is essentially a plan by which one chooses or decides how they want to dispose of their estate when they die.
Okay.
So
And
really what you're dealing with is the disposition of that wealth.
so when one passes away, there's got to be a way for those assets to be distributed.
Essentially.
Yeah. What's the importance of having a power of attorney? Is that different than an estate plan?
Power of attorney is part of the estate plan.
Okay.
Of course. The fundamental difference is this. A power of attorney is only effective during the lifetime of the person who signs it, which we call the donor, the person who gives the power of attorney. So it is a document that works during their lifetime, and it's a delegation of authority to people that you trust to manage your property in the event that you yourself become incapable of doing so, either by reason of an illness, an injury, or some kind of medical condition, something that would incapacitate you and would render you unable to manage the property yourself, in which case then your designated attorneys would take over that responsibility and manage your property on your behalf.
So really the continuing power of attorney is something that is important while you're living.
That's
and,
correct.
And incapable, whereas the estate part of it or the estate planning part would come into effect after someone passes away?
Well, they would have a will, and the will would come into effect after the person dies.
Okay, great. And I understand that there's a difference for a power of attorney for personal property and
Personal care.
personal care.
That's correct. So, like the power of attorney for property, the power of attorney for personal care is also a delegation of authority to people whom you trust. And the idea would be that if you were rendered incapable of giving directions to your doctors or making decisions affecting your well-being, then the people that you've appointed would step into that role, and they would make decisions for and on behalf of that person.
So this is really very important because you have to have somebody that you trust that's going to be making decisions for you that are, critical decisions.
Well, trust is what gets your foot in the door, as far as I'm concerned.
Right.
You would never appoint somebody who's dishonest, but what's required is somebody who is savvy, somebody who is on top of paperwork, not a procrastinator. Because remember that they're stepping into your shoes. They're going to be filing income tax returns for you. They're going to have to deal with accountants, lawyers, possibly investment advisors. You want people who are going to stay on top of these matters and not, just keep sliding them under the rug and then, potentially create a loss for you. So, yeah, it's a very, very sensitive position to be appointed to. And in my experience, I find that people don't give enough thought to who they want to take that on.
I agree, John, because in my line of work, obviously dealing with a lot of estate sales where people pass away and a property needs to be sold, the person in charge really does needs to be organized and because it's a big responsibility, and if you do drag your feet, it can go on for years.
Totally, and then you're increasing costs, which obviously the beneficiaries are going to bear in that there's going to be less available for them when everything is said and done. So yeah, you definitely want someone who is going to, you know, move
Be
to get
proactive.
things. Yes,
Yeah,
absolutely.
absolutely. Lena and I are going through this process right now, and I kind of feel like we've dragged our feet on it as well, because some of the decisions that need to get done when you're planning an estate are big decisions, and you really got to give thought to who's going to be involved in this process. So, you know, I thought that's probably one of the reasons why we should discuss this topic, because it's affecting us.
I think it's a really good idea, Carlo. There's a lot of misinformation out there. People have been led to believe that wills are basically forms that lawyers, you know, fill in blanks, and that you know, they're standard. And I'm not going to say that there isn't what we would consider boilerplate provisions that get included into a will, because clearly there are. But the considerations that go into how the will is going to be drafted, what the provisions are going to be, are really complicated, and you have to really take into consideration not just the extent of the person's estate, but also what it's comprised of. That gives an opportunity to discuss taxes, potential tax planning. Sometimes we get an accountant involved because the tax considerations are really quite complicated, and I'm not a tax lawyer.
Right.
So, you know, we do want to speak with tax experts to really put together a plan that not only fulfills the wishes of the person drawing the will, but that also preserves as much of the estate as possible against the possibility of tax erosion.
Yeah, I had this question to ask you last, but I think maybe I'm going to move it up here because I
Okay.
think it'll be appropriate here. Why would you recommend that somebody uses a lawyer to draft a will? Because I have seen online sites where you can, kind of like your boiler template that you were talking about, just fill in the gaps. But I know, having gone through the exercise with you, when Lena and I were sitting with you, you made us really think about some of the decisions that needed to get made based on what our circumstances were. And I'd hate to think, I mean, I'm sure those online portals maybe are appropriate. I don't know, but if I would have done that, I would never have thought of the things that you kind of triggered us to think about. So why would you say somebody should use a lawyer to put your estate plan together?
For that very reason, you know, we learn from our experiences, and obviously, you know, we continue to study in the area and look at cases and trends and things along those lines. And you know, legislation also changes over the years. So it gives the lawyer an opportunity to really discuss these things with the clients and see what the client's needs really are. And a lot of the times the client doesn't even know what their needs are until you make the issue a live
So
issue
true.
for them, right?
So true.
So I don't know whether a computer program is going to be able to engage the individual in such a way that makes them think about those things to even make them live issues for them. Now, that's not to say that the will itself will not satisfy the person's wishes.
Right.
I'm sure that if the person uses the app correctly, they'll end up with a will that definitely does what they wanted to do. But the question is that enough? And that's something that everybody has to answer for themselves.
Exactly. Well, for me personally, I'm so grateful that we've got somebody leading us through this process, because it really is complicated. So, okay, you mentioned will many times throughout this discussion. Is that different than an estate? Is it part of an estate?
It's part of the estate plan. So
Okay.
the will is just the document by which the individual directs how they want their assets disposed of.
Okay. I know, as working with people who are selling their properties, sometimes we need to wait for probate to be completed. Can you please explain to our audience what probate is?
Okay, probate is an old word. We really don't use that anymore. What we now talk about is making an application to the courts for a certificate of appointment of a estate trustee, either with a will or without a will. If the person doesn't have a valid will, then it would be without a will. If the person has a valid will, then it would be with a will.
Okay,
Now,
makes sense.
what you're essentially doing is bringing the will to the court so that it can be reviewed, and if it's deemed to be valid, then that certificate of appointment is issued to the executors, and they are then empowered to be able to do whatever the will requires them to do, whether it's to sell a house or distribute assets, whatever the case may be. Strictly speaking, it's the will that gives the authority to do those things.
Right.
But the court basically validates that authority by issuing the certificate, and having the certificate in hand actually protects the executors, because they now can prove that they are duly appointed and that they do in fact have the authority to be able to do the things that they're doing.
And how long does it typically take to get probate in Ontario?
That's a good question. A lot depends on the jurisdiction where you're making the application. So you have to apply in the jurisdiction where the deceased resided before death.
Okay.
So if it's Toronto, then it's downtown at our courts here. If it's in York Region, it would be in Newmarket. If it's in Peel Region, it would be in Brampton. And a lot depends on how busy those courts are. It's a slow and painstaking process. I've seen it take up to 9 months in normal times. Forget about events like COVID where it was really stretched out. But I've seen it granted in as little as 6 weeks. It really depends on how busy the courts are at that time.
Yeah, and I think that's something you really need to take into consideration if there is any asset that's being distributed as a result of the estate. I deal personally with properties that are being sold. It does take, like you said, we've had situations where, actually this year we had one that only took like 3 weeks. And we were astounded because that was crazy.
Yes, that is.
But typically 3, 6, 9 months, and certainly, like you said, during COVID, it was a lot longer. So you need to take that into consideration.
Yeah, the other thing that pertains to your business in particular, Carlo, is that sometimes what will happen is someone will be selling their house and they sign the agreement of purchase and sale,
Right.
and then they die. And now what?
What happens?
Well,
good question.
And it does happen, right? So then you're stuck because you need that certificate in order to move ahead with the sale.
Right.
So under those circumstances, you would go to the courts and you would actually say, look, we have this agreement of purchase and sale that was signed before the deceased died. Now we have a closing date that's pending, and we need this certificate. And what they'll do under those circumstances is they'll fast track it.
Okay.
They will not fast track it if the person has died already and then the estate is trying to sell it.
Okay.
They're going to say, no, you've got to wait.
Because that's a unique circumstance,
Correct.
Obviously. Okay.
Correct.
Now, sorry, we're getting a little off topic, but in that situation where the person dies in between transaction being done and closing,
Mm-hmm.
does the estate actually have the right to back out of the contract?
No. Standard wording in a contract says that it's binding on heirs, executors, administrators, and assigns. So
Exactly.
no, there's
Okay.
no backing out.
Good to know. Good to know. John, is there an estate administration tax in Ontario?
There is. It used to be called a probate fee.
Okay.
It's now called an estate administration tax, and it's roughly 1.5% of the value of the estate.
Of the estate. And does that take everything into consideration, all assets?
All assets.
Or are certain assets excluded?
Well, assets that are typically part of the estate would be included in the calculation of that tax.
Okay.
However, if you have things like RSPs or insurance policies where designations of beneficiaries are made in the documentation, then those particular assets bypass the estate and they go directly to the designated beneficiaries. So you would not include them in the calculation of the tax.
Are those assets that are specifically excluded, are they exempt from capital gains as well?
Let's not confuse one with the other.
Okay.
We're talking strictly provincial tax,
Right.
So they're excluded for the calculation of the estate administration tax.
Okay.
They may still be subject to capital gains tax.
Okay. Very important point there for
Yeah.
sure. What happens specifically related to real estate? What happens to a person's real estate holdings when they pass away?
Okay, first of all, you have to see how they're holding the title to the property. There may be another owner, for
Okay.
example, and that owner may own the property with them as a joint tenant. As you know, Carlo, the joint tenancy creates a right of survivorship.
Yes.
Okay, so if one of the joint tenants dies, then the surviving joint tenant becomes the absolute owner of the property, and the only thing that you need to do is register a survivorship application to delete the name of the deceased joint tenant. When that person dies, then again, the real property is part of the estate and it has to be dealt with according to the provisions of the will.
Okay, and if they are tenants in common, what happens upon
Okay.
death?
Tenancy in common, if it's not specified in the transfer,
Right.
the presumption is that the tenants in common own it in equal shares. So upon the death of one of the tenants in common, that person's interest falls into their estate and it would get dealt with according to the terms.
And the other half would be
would,
obviously.
would belong to
to
the
the other.
surviving
Okay.
yes, tenant in
Okay.
common.
Now, one of the important things about estate planning is picking beneficiaries.
Mm.
So we kind of talked about a little bit this topic off the top, but why is it so important, like when you're structuring your estate, that you're really thinking about who the beneficiaries are and how to choose them?
You know, Carlo, that's a very good question, and it's really quite complicated, believe it or not. We're about to see what, in my opinion, is the biggest intergenerational transfer of wealth
No doubt.
that the planet has
Yeah.
ever experienced. There are people out there who feel that they're entitled to a portion of Uncle Bob's estate because they've looked after Uncle Bob, because they've been very close to Uncle Bob. And then there are people who feel that they're entitled and they haven't seen Uncle Bob in 20 years. So when Uncle Bob is making his will, he's got to give very careful thought to how he's going to parcel it up. Now, generally, the rule of thumb is that he can dispose of his property in whatever way he wants, as long as his dispositions are not void for public policy. And we won't get into that too much because that's complicated
Right,
itself.
right.
But generally, there are no restrictions on Uncle Bob's ability to dispose of his estate. But he needs to be mindful of the fact that his nephews, who may not like each other, may not like the way that he's disposed of his estate and may try to challenge the validity of the will in some way or another, and in so doing, tying up the estate in litigation. Giving careful thought to how you want to dispose of it, who you want to leave it to, and if you know that there's a potential for disputes later, actually broach the issue with your family and say, look, here's what I want to do, here's why I want to do it, and I don't care if you don't like it, it's my property, I'll dispose of it whatever way I want.
You know what, John, that's such an important point. I know as we're going through the process, these are really difficult conversations that need to be had.
They are.
And if you do not have them while you're alive, these disputes can sit in courts for years before they get resolved.
They can. And estate litigation is extremely expensive.
Right.
And remember that we don't have the benefit of having the person whose will it is actually being able to stand up in court and give evidence as to why they did whatever they did. And at that point, their lawyer really becomes their spokesperson, assuming the lawyer's still alive, or has kept very careful notes. The other thing to consider is this, Carlos. Some beneficiaries, there may be physical or mental disabilities. They may be receiving some form of social assistance. So you want to consider before you leave them any assets, what effect it'll have on their ability to continue to receive those benefits, for example. Whether they're even capable themselves of being able to manage what you've left them.
Right.
There are some people who just don't have that ability. So in those circumstances, you would look at creating trusts as a way of getting the asset to that individual, but it never actually reaches their hands. Somebody else would manage it on their behalf.
Right. So many things to think about for
Mhm.
sure. John, what happens if somebody dies and does not have a will?
Good question. So we have a piece of legislation here in Ontario called the Succession Law Reform Act. And the Succession Law Reform Act essentially sets up a default will with a pecking order of who gets what
Okay.
in the event that someone dies, without a will. Again, it's kind of complicated. We don't really have time to get into it right now, but perhaps it's a discussion for another day. But the bottom line is that this default will does exist in the legislation, and somebody would need to actually apply for the certificate of appointment of a state trustee
Right.
without a will,
Okay.
so that they become empowered as the administrator of the estate, and then they would dispose of the assets according to the provisions of the law.
So the province wouldn't take over? It would be
No.
somebody applying?
Somebody would have to apply, someone within the family, and usually it would be a spouse, or a parent, or a child. You have to look and see what the family circumstances.
So what do you do if you've got a couple people who want to apply?
Good question. Sometimes you end up with a dispute over who should be the administrator of the estate.
Are there extra costs involved when there's not a will in place?
Only to the extent that the uncertainty creates potential for dispute.
Right.
Because if you have 2 or 3 people who each think that they should be the person, they're going to fight it out.
Yeah. Really.
And in the meantime, the property of the estate stays in limbo because it can't move forward.
Yeah. So, the reason we have discussions like this is to make sure that you're thinking about this ahead of time so that you don't get put in a situation where these disputes can occur between family members. And the very fact that you've had these conversations with your loved ones is so important, for sure. Yeah, no,
Agreed.
absolutely, for sure. How often should a will, or when should a will be reviewed? Is that something that should be done, or do you just set it and forget it?
The best practice for a lawyer when they're drafting wills for clients is to presume that this will is going to be the very last will that the client is ever going to do.
Okay.
You don't know whether the person is going to die or lose capacity to be able to make any changes to the will. So you really want it to be an expression of the intentions of that client for many, many years going forward. So it's sign it and forget it.
Right.
However, circumstances change, and people's intentions may change with those circumstances. So to review the will, not because it becomes invalid, but to review the will every 4 or 5 years, just to make sure that it still is a valid expression of what your intentions are,
Right.
I think is a very good exercise.
Yeah. Because people's lives do change. People get
Sure they do.
married, people get separated, have kids, they open businesses. You have to keep track of all these kind of big things or events that happen in your life.
Exactly.
Yeah.
And so, you want the will to properly deal with the estate such as it is at that time.
Right. Before we end up here, John, are there any things maybe that I haven't asked you that, maybe there's a point or two that you feel is important to get out to our audience, or have we done a good job covering it? I know it's complicated and you do need to sit down with your lawyer, but maybe there's something you'd like to share, I'm not sure.
Well, I think that I've been getting a lot of telephone calls from people whose parents have died, and they've been told that they don't need to apply for the certificate of estate trustee. And the idea there is that they obviously would like to save that 1.5% if they don't have to pay it.
Right.
There is a provision in the law which is called the first dealings exemption. This is very, very complicated, but I'll try to simplify it. Essentially, in the province of Ontario, we had 2 land registration systems that were running in parallel.
Okay.
Okay, and under one of those systems, we didn't need to go to probate or get that certificate.
Which system was that?
That
John?
was the registry system.
Okay.
Okay. So in order to deal with the property, the real estate property of a deceased, we didn't need to actually get that certificate. About 25 years or so ago, the province of Ontario decided that they were going to unilaterally convert those registry properties into land titles.
Okay.
And in land titles, you always, always, always need to have that certificate. Okay? So people complained and they said, look, I mean, my property was in registry and I wouldn't have needed to get the certificate. Now I will. Why'd you do this? So the province said, okay, we're going to create an exemption. As long as the property has not been dealt with since it was converted into land titles, we will let you deal with it as though it were still registered under the registry system. So no certificate required as long as there's a valid will.
And so you're exempt from paying the administration tax on that?
Maybe.
Maybe. Okay.
Maybe. So here's the kicker, okay? Assuming that there are no other assets in the estate that require you to have the certificate in order to be able to deal with those assets.
Okay.
So in other words, the house is the only asset in the estate, you don't pay the 1.5%.
Okay.
But if there's even one asset that requires the certificate, you now must include the value of the real estate with that asset in the
So
calculation.
you don't get that
So you-
benefit.
No, the only benefit is that you can go ahead and sell the property without waiting for the certificate because
Understood.
we can take advantage of the first dealings exemption. But they're two very different things.
Okay, great point. Yeah.
Yeah, so I get a lot of telephone calls from people in that.
Well, I know dealing with you on a couple of these matters for clients, we've come up, in those situations, and sometimes they work out, sometimes they don't. So,
Correct.
yeah.
Yeah.
Well, as you can see, the whole process of estate planning it's simple, but you definitely got to be proactive and give it some thought. And we hope that today with John that we've given you some things to think about and understand the importance of dealing with this proactively rather than waiting. So,
Yeah, there is one other thing that I do want to raise.
Please,
and,
yeah.
and I think it's important. Going back to the concept that people think that drafting a will is only filling in blanks. There used to be a time when lawyers used to look at wills as lost leaders. It was just a way of getting a client in the door and then hopefully keeping them for everything that the client needed after that.
right.
And so you would see a 1 or 2 page will and nothing else. And those wills, they could work, but generally they don't. There are all kinds of problems that we encounter with them when we go to try to get that certificate of appointment of a state trustee, and it would have been so much easier had the lawyer at that time taken the time to actually prepare a fuller expression of what that person's needs or desires are, to make the whole process of getting that certificate easier. So it adds cost.
So are you saying that the courts wouldn't recognize that?
They do, but it requires some massaging, and sometimes that's a little tricky.
Okay.
They just didn't go far enough in giving, the necessary powers that the executor might need or something along those lines. I mean, I'm oversimplifying it, obviously, for the purposes of this discussion.
Right.
Suffice it to say that a simple 1 or 2 page will is just going to cut it anymore.
Okay. We hope that you've enjoyed this episode of A Closer Look and really given you something to think about as far as the importance of having an estate plan, a will, powers of attorney. And John and I are in the process of putting together an information session for our clients and the people that we know, to put together, a session that we can get your questions answered in person, because there's, as you mentioned, John, a lot of things to consider. And John, I really want to thank you for granting us this time to really talk about a very important topic for our audience.
Carlo, it's been a pleasure.
I really appreciate it.
Yeah, well, I always try to help over.
Amazing. Thanks, John. And until we meet again, look forward to our next episode of A Closer Look.